Our top story this evening. There's some big relief for the one-time poster girl of India Inc., Chanda Kochhar. Chanda and Deepak Kochhar are all set to walk out of jail after the Bombay High Court granted them bail. The timing of their release is important because Kochhar's son is getting married on January 15th. The High Court has held that the couple's arrest was illegal. The judges also made it clear that the bail was not related to the upcoming marriage and was granted on merit. The Kochhars essentially had three arguments in court. Number one, they say the arrest was triggered by malefides because it was done close to their son's wedding. You see, the Kochhars were named in the FIR almost 4 years ago, yet they were summoned and arrested only now. Number two, the Kochhars say they were cooperating with the probe, that Chanda Kochhar had given 210 pages of statement and 810 pages of documents. Basically, they say they were cooperating, so there was no need for an arrest. And number three, Chanda Kochhar was arrested by a male officer. The arrest memo does not show the presence of a female cop, which is mandated by law. Essentially, they are arguing procedure was not followed while arresting Chanda Kochhar. The CBI, on its part, argued that the Kochhars were giving them evasive answers. So they wanted to arrest and confront them to learn the truth. As for the arrest procedure, the CBI said it was a white-collar crime and Chanda Kochhar wasn't even touched by a male officer. It's important to note that the bail order is not a win for Kochhars. At most, you can call it a temporary relief. Lawyers say the judgment does not alter the facts of the case. It merely relates to the procedure of the arrest. Which brings us to a very important question about agencies like the CBI, the ED and the NCB. Are they misusing the powers of arrest granted to them? In this case, the Bombay High Court certainly thought so. Let me quote some of the important observations that were made by judges as they gave bail to the Kochhars. They say, and I quote, "Merely because an accused does not confess, it cannot be said that the accused have not cooperated with the investigations. The reason given in the arrest memos appears to be casual, mechanical, and perfunctory, clearly without application of mind." Now, coming from a high court, that's damning criticism of the CBI. The court clearly believes the CBI abused their powers while arresting Kochhar. In fact, the court had a message to all policing agencies today. They said, merely because an arrest can be made because it is lawful does not mandate that the arrest must be made. Meaning, just because you can do something doesn't mean you should. It's a message to all investigating officials and judicial officers. The process of arresting someone cannot be taken lightly. When you arrest someone, you are effectively curtailing some of their rights. You are affecting their reputations and privacy. So there must be concrete reason to do that. If not, it's a direct assault on the person's personal liberties. Now, far too often we have seen cops jumping the gun. We've all heard about trigger-happy cops. Now we have a classic case of arrest-happy cops as well. The question is, when will all of this change? Will the Bombay High Court's scathing remarks be enough to strengthen out our police agencies, our policing agencies and all other agencies involved in investigating various cases? It's a question I'm going to be putting to my guest who is joining me this evening, Aryama Sundaram. Joining us, he's a senior advocate. Aryama, thank you very much for your time here on Mirror Now. You know, not too long ago, the Supreme Court, while hearing the Arnab Goswami case, had said, if constitutional courts do not interfere today, then we are traveling the path of destruction. Undeniably, we must send a message to the High Courts today that please exercise your jurisdiction to uphold personal liberty. This is Justice Chandrachud. Do you think that's what the Bombay High Court has done today?
Well, it certainly appears so. Let's understand one thing. Over the last few years, we have found more and more judgments from the Supreme Court which clearly recognize the importance of Article 21, that is the right to life and liberty. Now, Article 21 is really, in many respects, the basic right which is given to every citizen and has its origins as long ago as 1215 AD in the Magna Carta, when it was felt that no person can be committed without trial, that everyone has a fair opportunity of being heard, etc. Then we come across a period of time where it was accepted that jail is an exception, bail is a rule. And we also had a dictum that every man is innocent until proved guilty. We've seen a shift in that, where more and more we find that bail is being denied and jail has become the rule and bail has become an exception. The courts now, in the recent years, have shown very clearly that they value personal liberty as a very, very important fundamental right, and they will more strictly enforce it. Article 21 itself, which gives you the right to life and liberty, makes it clear that it cannot be taken away except by procedure laid down by law. Now, the procedure laid down by law is not merely a paper procedure. In fact, the judgments of the Supreme Court today have taken a reversal from the days of 1950 and 55 A.K. Gopalan's case, where the courts today say it is really not just a procedure laid down by law, but it is due process of law. That is, there must be a fairness, there must be a justness, and above all, if there is a procedure, the procedure has to be strictly followed. What the Bombay High Court has said in this case, that they are not satisfied that the procedure has been strictly followed. And if the procedure has not been followed, then there is a violation of Article 21 on the face of it. They've also gone on to say that the reasons for arrest do not appear to be fair and just, and have gone so far as to call it arbitrary. I'm not commenting on the correctness or otherwise of the judgment, but in the larger sphere of things, it is very clear that the Bombay High Court has adopted the age-old principle of A, the importance of following procedure when you're going to deny a person of their liberty, and B, the importance that it should be actuated by reason and not just be purely arbitrary. And that is a reiteration of what our Constitution really said and what it intends, and that's keeping in line the view of the Supreme Court today, which really makes it very clear that the right to life and liberty is a very precious right, and to deprive one of it, then it should call for sufficient satisfaction that it is necessary in the interests of justice. The Bombay High Court, obviously, on seeing the records in this case, has felt that was not satisfied, and therefore has merely laid down. I cannot comment on the correctness of the judgment, not having seen the records, etc. I'm not on that. But what the Bombay High Court has satisfied itself, that the grounds made do not warrant such an arrest, do not warrant the deprivation of liberty, and therefore has given its verdict. And I think that's very important in that it's reiterating the importance of the right to liberty and the necessity of a reasonable, of good reasons why a person should be arrested, that it is injustice that they should be arrested, that it is not something which is just done at the whim and fancy of the investigative authorities.
You know, the observations today have been scathing. First, they are saying you have not had any communication with these people for 4 years and suddenly you go arrest them. The reason, the reason for arrest in memos has been done without the application of mind. Arrest cannot be on whims and fancies. Refusal to confess does not mean non-cooperation. Now, this is not the first time that a court in this country is giving a scathing lesson, as it were, to our agencies, to our probe agencies, whether it's the police, the CBI, the ED, etc. We've seen it in other cases as well, haven't we? We've seen it in cases regarding politicians' arrests. We've seen it in the case of Aryan Khan as well. But it seems it doesn't seem to be having an impact, Mr. Sundaram.
Well, there you've got to really call up the officers if the courts are satisfied that it was completely unwarranted, that it was arbitrary, that there was no sufficiency of reason to arrest, that procedure was not followed. I think it is time to haul up such officers to set an example in one or two such cases, which will automatically act as a deterrent to other people from, sidestepping the law, sidestepping what is required before they make such an arrest and deprive a person of liberty. I feel it is time that an example is given in a given case where the court is fully satisfied that it has been a totally arbitrary and unfair exercise of power in depriving a person of their liberty and haul up the officers responsible for it. I think if that is done, then perhaps that will act as a deterrent, and in future, other officers will be more careful about how they exercise their rights.
Aryama Sundaram, thank you very much for joining us and helping us decode that order. Legal language can often be confusing. So thank you very much for joining us. N R Wasan is a former Director General of the NIA. He's also a former Joint Director of the CBI. He's joining us on the broadcast. Swapnil Kothari is a senior lawyer as well. Mr. Wasan, is that what we need to do? To haul up officers in court so that these quote-unquote illegal arrests just for harassment don't happen?
Yeah, I will agree to a great extent. And this problem, as you pointed out in the beginning, this problem has not started in the last 10 years. I joined service 40 years back. This problem is persisting since then, and people are being arrested when they need not be arrested. Let me tell you one more thing. As far as I know, because I left CBI long back, in the CBI manual, there is an instruction that person will not be arrested if he is cooperating, and then there is no scope of his or her tampering with the evidence or trying to influence the witnesses. The manual itself lays down that guideline. I think that guideline was not followed. And here in this case, as pointed out by a senior advocate, they sent the summons after 4 years. The preliminary inquiry was conducted in 2017. A case was registered in 2019. And I think only one summons was sent to the accused in beginning of December or end of November. And then second summons was sent. And they were interrogated and they made statements. Now, I agree with the High Court that there is no requirement that the accused must confess or accused must agree to what the investigating agency will like to hear. The accused has a right to silence. We must recognize that. Unfortunately, the police officers do not understand the legal nicety and they go and arrest because they think they have the power. And especially agencies, central agencies like National Investigation Agency or Central Bureau of Investigation, they need to set an example because the local police looks up to them. If they do not follow the law of the land and if they sidestep the law, as my co-panelist said, then I shudder to think, what will happen to the law of the land.
Why do they do it? My own sense is, Swapnil Kothari, whether it was in Aryan Khan's case, whether it was in Sanjay Raut's arrest, which a court itself had called a witch hunt, whether it is in this case and just the case of the arrest. We are not talking about the larger case. We do not know whether Chanda Kochhar is guilty or not. That's a separate case altogether. But just pertaining to this arrest, do they go specially hard on high-profile faces and names because they don't want to be seen to be, being nice to anyone, especially not the rich and powerful? I don't know what they're thinking, because it's not the first time that our agencies are getting wrapped by the court. It just seems they're not listening. They don't care, because as far as I know, the CBI is now going to the Supreme Court to appeal against this bill.
Shreya, let me tell you, as far as Mr. Raut or Mr. Aryan Khan's case is concerned, people could be having differing views as far as this is concerned, and the agencies perhaps could have been justified initially as far as that is concerned. But thereafter, if the custody was extended, it was extended so by the lower courts, and that's where then the lower courts went wrong. They should not have extended the custody. They should have given the bail themselves, failing which then the victims had to approach, or rather the accused had to approach the Bombay High Court and then get the bail themselves. But as far as this particular case is concerned, there seem to be too many lapses in this. I mean, for 3-4 years, you don't arrest a person. Suddenly you come out of the blue, you send a 41A notice. And then, even when the person is seeming to cooperate, I mean, you have got 800 documents and 210 pages of several confessions or admissions as what you call it cooperation. If that's not cooperation, then what is? And, thereafter also, then you go ahead and arrest someone. What you're saying, Shreya, could perhaps be true that psychologically they could be thinking that if we let off these people, it may come across as that, we are cowed down by powerful people, etc. But I don't think that should be the case. That should be governing the minds of the authorities when they go ahead and do this. I don't know what's happening with respect to each particular case. I mean, what is it they're thinking? But this case, on the face of it, from the way the records have been examined by the High Court, I think it clearly looks to me, Shreya, that this was, I think they had gone a little tad too far. And one of the most important things is that when you handcuff a person, you are basically handcuffing a personal liberty of a person. Basically, that's what you're doing. And at the same time, your handcuffs better be replete with procedure. And not only procedure established by law, but, so as to go ahead and say that Supreme Court in several of its judgments had said due process of law. That means you establish in your mind whether this person really needs to be behind bars, whether I need to snatch the liberty of the person, whether this person is cooperating, non-cooperating, evasive, etc., all of those things. And thereafter, then you come to a decision whether you want to make an arrest. And most importantly, you cannot forget Article 20, Sub-Article 3 of the Constitution, which says that no accused can be a witness to himself or against himself. No right. That means what you call it as a right against self-incrimination. I'm not supposed to say anything that can go against me. That's a constitutional right. And constitutional right, and that to a fundamental right, prevails over all these procedural laws that you and I are talking about, whether it's CRPC, whether it's evidence, whether it's IPC, all of those things. So that is where these people have gone fundamentally wrong.
But I'll say, okay, but I'll say one thing, that today the Bombay High Court has not just come down hard on the CBI or the cops, but they've come down very hard on judicial officials as well, saying that they overlook the mandate of the law. And, one of the things that the court said, and I'm going to quote from there, Mr. Wasan, is routine arrests can cause incalculable harm to reputation and self-esteem of the accused. We've seen that in Riya Chakrabarti's case. We have seen that in Aryan Khan's case. Kya hua uske baad? Kuch nahi hua, right? But their reputations have been harmed forever. You have dragged them through mud. And what has happened by the end of the day? Nothing. Zilch. No evidence found. I'm not saying that will be the case here, in this case. But I'm saying that before you're making an arrest, before you're leveling those charges, think about what it is doing to a person's, not just personal liberty, but their reputation as well, their anxiety, their mental stress as well, to their self-esteem as well. Our agencies don't behave like they are populated by human beings. The process cannot be that cold and cruel, is what I'm trying to say.
No, absolutely. You see, the issue is these people are known. They are known in the society. We are talking about them. But what about thousands of arrests being made which are not to be made? There is no necessity to arrest common man. And they are being arrested day in and day out. Because they can't go to courts, they can't approach the higher courts, they don't have money, they can't hire advocates. They are suffering. These 4 or 5 instances, we can talk about it. But the system needs to undergo a radical change. The police officers must understand and must respect the law. It can no longer happen that you can be arrest happy, like the trigger happy cops. You can become arrest happy cops. Now that's a situation which I dread, and unfortunately, it is happening all over. The state police are doing it. The central agencies are doing it. There has to be a radical change in our mindset. The police officers have to retrain to think objectively and arrest people only when it is mandated by law and it is absolutely necessary for professional investigation of a case. Otherwise, arrest should not be done.
Okay, and as I end this, Mr. Wasan, and Swapnil Kothari, I just want to tell our viewers, at no point here are we trying to say that Chanda Kochhar is not guilty. Absolutely not. We don't know. The CBI is investigating the case. Before that, the ED was investigating the case. We don't know whether she is guilty or not, whether her husband is guilty or not, whether Venugopal Dhoot is guilty or not. We don't know. That's not what this debate was about. What this debate was about was the way our agencies go about arresting people, even when there is absolutely no requirement for them to do so. Today, the Bombay High Court has called Chanda Kochhar's arrest illegal. Essentially, the court has said just because the cops and the agencies can arrest people doesn't mean they do arrest people. We leave it there for the moment. Chanda Kochhar and her husband Deepak Kochhar will be walking out of jail tomorrow. They were supposed to walk out of jail today, I believe, but that's been held up. So tomorrow is when it will happen now. Meanwhile, the CBI, we are being told, will be approaching the Supreme Court against this bail that has been granted to Chanda Kochhar and her husband by the Bombay High Court. We'll leave it there for the moment. Mr. Wasan, thank you very much. Also good to have you, Swapnil Kothari, on the show. Thank you very much for joining us on our top debate this evening. Let's shift our focus now to Joshimath.